New Haven. On the Tuesday before Thanksgiving, Leroy Harris appeared in court and pleaded guilty to kidnapping and robbery. The plea was a legal fiction and everybody knew it. He knew it, the prosecutors knew it. The judge knew it, too. Nearly 30 years ago, Mr. Harris was convicted of raping a woman in this Connecticut city, a verdict he has been trying to reverse ever since. Earlier this year, after decades of fighting his appeals, the Connecticut State's Attorney's Office finally conceded that the evidence against him might be tainted. The prosecutors agreed to let him go if he took a deal. At the heart of the deal was something called an Alford plea, an odd legal paradox that required Mr. Harris to formally plead guilty to a set of lesser crimes, but not admit that he had actually committed them. After he played his role in this courtroom drama, the judge reduced his sentence to the years that he had served. Mr. Harris was freed on Tuesday evening in time to spend Thanksgiving with his family. But the prosecutors also walked away with what they wanted. At least on paper, they were able to preserve their conviction. That ensured they would not have to conduct a second trial or face the consequences of bungling the first. In recent years, plea bargains of all sorts have dominated the criminal justice system. They now account for almost 95% of the final dispositions in felony cases across the nation. Even the Supreme Court has acknowledged their preeminence, writing in 2012 that criminal justice today is for the most part a system of pleas, not a system of trials. Alford pleas, however, are exceptionally rare, composing only 6% of all the guilty pleas in state and federal courts, according to a study published in 2009. While some legal experts have assailed them as a patent violation of due process rights, others have described them as a psychological salve. They allow defendants to maintain their innocence even as they bow to the reality that they would likely be convicted at a trial. But then there are defendants like Mr. Harris, who entered his plea decades after his conviction and only, as he put it, under duress. Across the country, different prosecutorial agencies take different positions when facing cases that might be marred by a wrongful conviction. Some, like the Brooklyn District Attorney's Office, have decided that the most just option is simply to reverse a bad conviction and wipe a defendant's slate entirely clean. But others use guilty pleas and sentence modifications to free people from prison in dubious prosecutions. In Mr. Harris's case, the prosecutor who tried the matter had not disclosed exculpatory evidence. Scientific testing also showed that DNA on the victim's clothes could not have come from him. The victim failed at first to pick out Mr. Harris in a photograph array, but then, at trial, identified him for the first time as the man who had attacked her. Earlier this year, a Connecticut judge made it impossible to rely on her testimony, ruling that prosecutors could no longer use witnesses whose sole identification of a suspect came in court. Legal experts say that even if defendants who enter guilty pleas are eventually released, they are often subject to collateral effects that could include losing government benefits or the legal right to vote.